number 12, Plavin versus Group Health Insurance Incorporated.
Thank you, Your Honor. May it please the Court, Caitlin Halligan for Mr. Plavin. I'd like to reserve 2 minutes for rebuttal.
2 minutes, Ms. Halligan?
Yes,
2?
Your Honor. Thank you.
You may, of course.
The answer to this certified question is straightforward. GHI wrote and distributed marketing materials advertising its health insurance plan to Mr. Plavin plus more than 600,000 other New York City public employees and retirees in order to persuade them to pick the GHI plan over other options. In those materials, GHI described its coverage of out-of-network services in terms that Mr. Plavin alleges, and the Third Circuit agreed, were materially misleading because they created unrealistic expectations about how much GHI would pay for out-of-network services.
Counsel, in your case, you have these 11, I think, different plans, and you have hundreds of thousands, I believe, or at least more than 100,000 current former employees.
600,000, yes, Your Honor.
And so you can see this in an analogy to a marketplace and a choice in a marketplace in marketing.
Yes.
It seems your opponent's rule would be fairly clear-cut. While the facts of your case are compelling in that way, where would this court draw a line, or where could we create a rule based on this type of scenario, where it really is somewhere, I guess, in between NYU and Oswego, right?
Right. So, Your Honor, I think that Oswego and Gaydon together really do answer this question, and that's why I say that it's straightforward. So in Oswego, the court lays out the test for when conduct is consumer-oriented, and it says you have to look at whether or not it affects just the plaintiff in front of you, which is obviously what happened in NYU, or whether it potentially affects a wider group of similarly situated consumers.
10 employees, one health care plan, but you have the option to get your own outside of your employment. How would that fit in your test?
10 employees would perhaps pose a different question. When we looked at the case law, I think the smallest number of consumers we saw was 143. So 10 employees would pose a different question there, right? But really what GHI is asking this court to do, Your Honor, is to focus on the wrong party and the wrong transaction. It's the only way they can claim that NYU has any traction.
And I understand, and I follow that argument, and I particularly think it's compelling in this case on these facts. But if we go into that direction where we're applying it here, 173, I think it's upheld, that number seems so arbitrary. What kind of guidance would we have to give to in some way place limitations between this case with 600,000 and 11 choices to a handful of employees with one choice, or you go your own way?
Well, I think a handful of employees, we could set to the side and would not in any way be touched by this case because there's 600,000 employees. I think the question that Your Honor is perhaps getting at is, does it make a difference that the access to the marketplace here is provided pursuant to some arrangement with the city? And this, it doesn't for the following reason. First of all, this is a case that is very much like Gaydon itself, right? So in Gaydon, what the court did is it said, this is not a dispute about whether or not there was a false guarantee made in the policy. It's not about the terms of the policy. It's about whether or not the extensive marketing created unreasonable expectations, unrealistic expectations about coverage.
But my concern really more is with the marketplace.
Yes.
So in this case, you can say 600,000 people has the attributes of a marketplace, but 20 people, does that have the attributes of a marketplace? The same facts,
right,
or fewer choices. You can move the variables, but where do we draw? This is aimed at something, right? And here again, you have 600,000, but the next case we won't have 600,000.
Right, and I think that if the court is confronted with a case where there's 50 consumers, for example, that what might be harder. The appellate divisions have looked at this consistently over the years, and they really have found that where there is some material number, 143, or for example, the members of of an auto insurance policy where they all go to the same auto repair shop, right? That can't be that many individuals who all go to the same auto repair shop.
But does it matter whether the choice is between one offered by the city and some others maybe not offered by the city? as long as there is a choice. So in other
Your Honor,
words,
I actually don't think that the fact of the choice matters here, and this is why. The question of whatever GHI and the city agreed to that allowed GHI to access this marketplace is completely irrelevant and not before the court. The contract itself, whatever it might say, we don't have, it's not in the record. So whatever those terms are, they're not before the court. And I would urge the court to look at the certification order from the Third Circuit, where the court says very clearly the only documents alleged to be in the plaintiff's hands, and this is the constraint, maybe this goes in part to your question, Judge Garcia, how do we cabin a ruling here? What the Third Circuit says is he had two documents. They're both marketing materials solely authored by GHI that describe the plan. So in that regard, it's no different than Gaydon.
But that's not the point of my, the point of my question is that the consumer
Yes.
has a choice whether or not to select that
Yes.
insurance policy. And the conduct that's alleged here is that GHI was deceptive
Yes.
in promoting its insurance policy over whatever other choices there might be, whether it's one or two or inside the city or outside the city program or whatever. The point is that that's the deceptive conduct.
Yes.
Choose our policy because it offers you X, Y, and Z, where there's any choice at all.
Yes, yes. And so that is exactly part of the deception that we are addressing here. And the Attorney General's brief points out an additional type of deception that would not be at play even if there is no choice. And that type of deception is the following. If you as a consumer are trying to decide whether or not to go in network or to go out of network, you will probably care, we all care, what kind of reimbursement you're going to get for those out-of-network services. So one question is exactly the one Your Honor identified, Judge Stein, which is, do I pick GHI, which is billing itself as a PPO in a meaningful sense because it's telling me that the reimbursement rates are substantial for out-of-network services? That turns out to be one misrepresentation. The second misrepresentation, and the Attorney General's enforcement efforts have been robust in this regard, and my adversary's reading would really curtail the ability to police the marketplace in this way, is if the the marketing materials say there is substantial coverage of out-of-network services, if I may just finish my answer, and you pick out-of-network services, and then you are stuck with a large out-of-pocket bill. That is a separate kind of misrepresentation that the Attorney General's office has policed using the powers provided under 349, and very much like the kind of misrepresentation at issue in Gaydon.
Thank you, counsel. Counsel?
May it please the Court, John Gleason for GHI. I want to start, if I may, addressing Judge Garcia's question. And it's kind of an interesting situation we have. The Third Circuit said to us, would you like us to certify questions? And we both said no. And the Plavin
We
folks,
didn't, though. We were stuck with it.
yeah, you said, right. Don't blame us. We said to the Third Circuit, first Plavin said, no, this a straightforward application of Oswego laborers means we win. And we said, no, don't certify a question because the straightforward application of Oswego laborers and NYU means we win. Now, I'm going to suggest this case doesn't fall in the middle, Judge Garcia, because there's a principle that underlies those two cases, Oswego laborers on the one hand and NYU, 10 months apart. And the principle is this: it doesn't have to do with the size of the class. It has to do with what the consumer protection law, what the GBL 349 and 350 protects. And it protects against the imbalance of bargaining power that inheres when a consumer deals with a large company. So
why is that not the case here? Because it seems to me that the answer to that depends on whether you focus on the insurance contract and the negotiation of that contract between the unions and the city and GHI, or whether you focus on the communications between GHI and the employees. Don't you get a different answer depending on which of those two things you focus on?
Judge, a fundamental flaw in the argument is that the premise that on which the GBL claims are supposed to be involved in this case is that there's this market. The premise is that there's competition among the plans chosen by the city and the Municipal Labor Committee. And in fact, there is none. And in fact, this is not a stationary target, this argument. In the district court, the argument against the application of NYU was not that there's a secondary part of this market where there's competition among the plans. In the district court, the argument was, no, NYU is a university, and we're not, and we have 600,000 members. This argument is of recent vintage, and the argument is, after the MLC, which represents the city workers and retirees, and the city arrive at an array of plans, then there's competition at that point.
Maybe I misunderstood the arguments, but I thought the argument against NYU applying here was that in the NYU case, the policy there was tailored for a particular need and it was not a standard policy, what's known as a bespoke policy. And I thought that was the distinction that was drawn.
Yes, that's our distinction. Mm-hmm. District Court agreed with us. And there, now, the reason the lessons of Gaydon and Oswego help us is those are cases. Oswego involved a plaintiff who was dealing with the same off-the-rack signature card that gave information about interest rates, kind of a cute case, interest rates and savings accounts, and that's the same card that was given to everyone who walked into the bank. The same thing with Gaydon, those vanishing premium, the information about vanishing premiums, which was deceptive, was information given to all of the policyholders.
But I thought that they were particularized. They gave particular projections or whatever for each individual. Does that make any difference?
They did, but the deceptive part about the allegedly deceptive nature of the communications was the same with respect to everyone who dealt with the insurance company. That's what made it consumer-oriented conduct. Whereas in NYU, when there is a bespoke contract negotiated, this is the key. This is what the NYU case 10 months after Oswego made clear. When there are sophisticated negotiating parties on either side, the whole point of the GBL is to protect folks who suffer from
NYU, it was that sophisticated party who negotiated the contract who was then making the GBL claim.
Yes, and here, what makes this case unique, I'll suggest respectfully to this court, is there is an elaborate statutory scheme. It's been going on for 50 years, since the mid-'60s. The first backbone of it is an obligation on the part of the city to pay 100% of the premiums for city workers and retirees' health benefits. At the same time, the MLC, which has a statutory, state law, local law, federal law, duty to protect the interests of those employees, was created for the express purpose of negotiating, selecting, and administering the health care plans. The point I wanted to get to earlier is
doesn't all that mean, and you correct me if I'm misunderstanding this, all that means is that there's a government entity that's going to pay, and that it has said, we're going to limit the universe from which our employees can choose, but choose they must. So we're still back to whether or not 349 then protects the information that the chooser, the employee, has in that choice process. Or have I misunderstood what goes on in this process?
Yes, you have, respectfully.
Okay.
The choice that is posited by my adversary doesn't exist. The MLC and the city arrive at a bespoke selection of plans. They don't compete with each other, Judge Rivera. This is the only...
I mean, the employee can't say, I want this plan versus this plan.
They can, but 95% of them end up in the only... This is paragraph 20 of their complaint. This is the only provider organization plan that's no premium that's offered. And this is the one that was selected.
Oh, it's the best deal, so
And
we can see
it's
why
the
the
best-
choice works in that
And
direction.
it's the
Isn't that
only
core of
deal
the-
of that type.
Isn't that the core of the argument, though? Is that they end up there because the argument is this is the best deal, but of course, the AG argument is, the argument on the other side is, no, it's not the best deal. It's only the best deal because their allegation is that deceptive business practices make it appear to be something that it isn't.
Well, obviously, we have answers
Okay,
to the
so
deception.
that being the case, and it's based on the claim that if you're out of network, you only get somewhere between 9 and 23% of your costs actually provided for, unless you buy an optional plan that is claimed that there was misleading advertising for. So that's the way I understand their argument.
Judge Fahey, this is, obviously, this regime has been in existence for a very long time. This is an outlier case. You are not going to find a city worker.
Am I wrong in those numbers? Am I wrong in those allegations?
I'm sorry,
Are those allegations incorrect? Are those numbers incorrect?
the numbers.
The numbers,
forgive me.
9% to 23% in out-of-provider costs.
Oh,
And-
no,
and- Because the way I understand it is, it's not simply the contract, it's also the website and the summary program description that come into play here in terms of the marketing practices and hence the allegation for deceptive business practices.
it is true, and it's explicit in the program, that the out-of-network benefits, this is a city worker program.
No, I know what it is. I know what it is.
A retiree
I got it. Yeah.
moves to Middle Pennsylvania.
Or he's a police officer, I got it.
And it's true that the out-of-network benefits are pegged to a 1983 schedule, and that's explicit. It's true that the example given in the summary program description and in the,
Was that schedule provided to the retiree?
that schedule was available to, there's a dispute about that. The schedule was available by calling up GHI folks. As you know from the amicus brief, that schedule, that information is available at the local level every step of the way. The local, which answers to the specific union.
Local GHI, you mean?
No.
Oh.
The local of which the city worker is a union member, 102 of them, under the umbrella of the MLC. They provide information. That information gets funneled up to the MLC, which negotiates with the city. My point, Your Honor, is every step of the way, there is a, can I answer the question? Can I finish my answer, Judge?
If I may,
Kiefer?
also, I have
Yes,
a
of course.
question.
Every step of the way, there is a sophisticated, created by statute, this is a unique statutory scheme, the insertion into which of a GBL claim will cause great havoc. But every step of the way, the kind of sophisticated bargaining assistance, this court premised the principle of the consumer-oriented conduct on an NYU. Every step of the way, an entity like that is holding the hand of the union member, which is why, Judge Fahey, you haven't seen these claims. You're not going to see a claim like this. You can search the case law for it. And if it exists, it's a claim that exists not only against the insurer, it exists against the union.
All right,
It exists against the city.
Mr. Gleason, I want to come back to something that you alluded to at the beginning of your argument, and I don't know that you've fully fleshed it out, and that is, how is it that your position actually squares with the legislative history and purpose of the GBL, which seems to cover a broad array of deceptive conduct? And you started there, but then I think you got to ask the question. And so
Well,
I'm just curious if you can give me that in a
Yes.
nutshell.
The legislative history and the purpose of the GBL, as made clear by this court, in among other cases, NYU, the legislative history is to protect the consumer, it's a consumer protection statute, from circumstances in which the consumer suffers from a disparate bargaining power situation. That's the critical purpose of the GBL, and that's why it's such a generous cause of action. It doesn't require a fraudulent statement. It doesn't require a statement on which the consumer relies. It's a very generous cause of action designed to compensate for that imbalance in bargaining power. Once you have a situation like this one,
Well, how is that true in Oswego? Those are some pretty substantial organizations, right, and funds?
it was, communications there were by a bank. Everybody who walked into that bank was given a signature card that gave misleading information about the interest that would accrue.
But what I'm saying is between the plaintiff in Oswego and, or the funds, right, and the bank, you're not talking about a small consumer off the street there, like you seem to be espousing as the standard.
Well, Judge, we don't have before us for one thing, it's not a bespoke arrangement, so it's not being negotiated. And we also.
So it's not just about the bargaining power, so
Well,
that takes us out of that, doesn't it?
And I'm basing my argument on a growth in the case law that came 10 months later with NYU. NYU made clear that it's the consumer-oriented communications are ones that are addressed to everybody. That's Oswego. But when the communications are made in a context where there's a sophisticated bargainer who's there to compensate for the imbalance in bargaining power, that is not.
And just to clarify, you're saying Oswego stands for the proposition that it only falls on the 349 if it's truly, truly something that's for every member of the public?
Well, it not only does, but it certainly does, if it's outward-facing communication that every customer who walks into that bank faces, and it's allegedly deceptive.
So it's still a subgroup. It's the group that's interested in that bank. So they've made a choice already to at least walk into the bank. How's that not like making this choice here about what plan I want?
Because there are other banks on that street into which that person could have walked.
What are the plans? Here, I understand your
there's-
point that this is the better deal, but nevertheless.
Well, I'm going to rely on plaintiff's own allegation. Can I finish?
Please do.
Judge, thank you for giving me more time than I deserve. There are other banks on that street. There is no other plan. The whole point of this apparatus, a highly structured statutory matrix, is to deliver this no-premium PPO organization plan to city workers, and there's only one of them.
Isn't
There's
the
no
logical
competition among them.
extension of this argument that unless everybody was going to use a bank and make a choice, then it's not consumer-oriented? You still have only a subgroup of people who want to use a bank.
Yes, only some people will want to use the bank, and it's only that category of folks who are putative GBL plaintiffs.
Thank you.
Well, just to go back to something Judge Rivera was asking you earlier on the facts or how this works, and I may also misunderstand it, but I thought these contracts were negotiated, and then there's this pool of folks, current, former, they then make a choice. Is the revenue that your company or other companies make ultimately dependent on how many people choose to go with your company? Or, because otherwise I'm not really understanding what's the point of the choice.
The second part, Judge Garcia, is right, but the first part is there's no choice. 95%, because it's the only PPO plan
But I
with
think
no.
that gets to Judge Fahey's point, which is that may be true in terms of the numbers, but that may be giving them, assuming their allegations are true, because some part of that number may be because people are under a false impression, a misleading statement was made about why they should go with that plan. So ultimately, I think the numbers aren't as important as what's the effect of the choice. I mean, is the effect of the choice that your company gets its revenue from the folks that agree to sign up with your coverage? Because that, to me, is a consumer choice, right? Where do I essentially spend dollars?
The choice here is made in advance of the city worker selecting a plan. There's a choice of a no-premium PPO provider that's made by the city workers and retirees representative, the MLC, the umbrella organization. They make that choice with the city in an elaborate process. I'll finish, unless there's another question, by saying this. It's instructive. I'm glad the amicus brief from the MLC cited the decision of MLC versus City of New York, which, and I commend that decision, which is cited in that brief, to this court, because it shows how highly structured and how under the control of the city workers and retirees representative, the MLC, the whole process is the city decided several years ago, this is a 2013 case, maybe we shouldn't use GHI to deliver this one PPO plan that has no premium, and began to engage in that process without including the MLC. MLC got them enjoined because that statutory matrix and that 1992 agreement mentioned in that amicus brief put in control of the selection of the plans which are then delivered to the retirees, puts that control in the hands of their representative.
But is your point that you have only one choice on a PPO, but you can choose between a PPO and a non-PPO, and most people choose the PPO? Is that what you're saying?
As it's evidenced better in the amicus brief than it is ours, I'm sorry to report. But no, those other non-PPO, no premium, are kind of specialty. People, as described in the amicus brief, if you've got a special physician need or a special pharmacological need, you're a member of the Health and Hospital, an employee of Health and Hospitals Corporation. They have a special little program. All of those combined comprise only 5% of the city workers and retirees. The rest enter into the program selected, negotiated, and administered for them by the representative as to which they're owed a statutory duty of good care, a fiduciary duty of good care.
Thank you, counsel.
Thank you.
Counsel?
Thank you,
Counsel,
Your
can you
Honor.
address this argument, which I take essentially to be choice is illusory, the real choice has already happened through that negotiation process with the city? And
Absolutely, Your Honor.
Can you
Two
address that?
responses, if I
Yeah.
can. First of all, I think Judge Fahey has it exactly right. The point here is not with respect to whatever a contract, not in the record, not before the court, not before the Third Circuit might say. I don't know what it says. The point that these claims are based on is, just like in Gaydon, the marketing materials that were extensive and were standardized and were sent out to 600,000 employees without any oversight by the city were misleading. And the reason they were misleading is that they made the plan look more attractive than it was, and it made it look like a better deal because it suggested that the key factor that would make you pick a PPO, if you could afford it, which is how much are you going to pay for out-of-network services, that coverage was better than it really is. That is the nub of the claim here. And so,
what is the choice? I am a little confused now, because I thought it was the choice originally between this plan and 10 others.
it is, Your Honor.
Then I thought it was this plan and non-PPO plans, but it seems, at least according to your adversary here, that it really isn't, that this is the plan and these are other specialty plans that...
Your Honor, first of all, I would say, with respect to my friend, Mr. Gleason, I don't think there's anything in the complaint or the record that supports this. And this case comes before this court on a motion to dismiss. So the only thing that's before you are the allegations in the complaint. There are descriptions that the marketing materials that were sent out, both through the summary plan descriptions and the website, are appended. And that's all that's relevant. The only question is whether or not those were consumer-oriented.
One other factual, just clarification.
Yeah.
I thought that there were two PPO plans.
I believe that there were, Your Honor, and I don't think that there's any basis in the complaint or the record to describe any other plans of specialty or otherwise. I don't see any basis. But in any event, one other point, if I see my time is up, if I may just respond to two other points briefly. Judge Stein, you asked about the schedule. The schedule was not available according to the complaint. Again, you're bound by the allegations in the complaint, and the Attorney General's assurance of discontinuance makes clear that it was indecipherable in any event. So that is, I think, not a defense. And in any event, that question goes to something the Third Circuit has resolved, which is whether or not the misrepresentations are misleading. The Third Circuit found that they are. The only question the Third Circuit thought was open is whether they were communications to consumers. One last point, if I can, and My adversary says that this is a one-off case, not just with regard to somehow all of the city's public employees being like a billion-dollar university with a bespoke contract for shoplifting. Obviously, that comparison, I think, falls flat, but suggests that this is a sport and this court can decide it, and it won't make much difference. That is absolutely wrong. The Attorney General's office explains why it is that this is a critical enforcement question. There's no reason to think there's concern with regard to anything that the city or the unions would do. The city's a frequent litigant in your court. I am sure that if it had those concerns, it would have made an appearance and it would have said so. And I would close by saying that at the end of GHI's brief, it says, well, if you disagree with our reading of 349, we won't cooperate with the AG's enforcement efforts when they look at whether we are making misrepresentations to consumers. I would say that that underscores that Mr. Plavin and the other city employees are exactly the kinds of consumers that are in need of the general business law's protections for all the reasons in the legislative history that Your Honor set forth, Judge Feynman. Thank you.
Thank you, counsel.